In this video, I'm going to take a look at bullying in the workplace and what the legal remedies are for bullying. One of the most common complaints that I meet when I meet employees all the time is a complaint about bullying. But quite frankly, a lot of employees are not entirely sure what constitutes bullying from a legal perspective. And you need to be very, very careful before you embark on any course of action in relation to bullying that the behaviour about which you complain is and does constitute bullying. Now, bullying is repeated inappropriate behaviour that offends the dignity, your dignity in the workplace. That's essentially what it is, but it is repeated, it is persistent, and it must offend your dignity in the workplace. Management, rough management, or a one-off incident, or some sort of a slight, or perhaps a one-off shouting match or something like that, or a disciplinary procedure or a grievance procedure that goes wrong doesn't necessarily constitute bullying. So you just need to be aware of that at the outset and double check that the behaviour you're talking about does constitute bullying. If that's the case, then we'll take a look at the remedies, the legal remedies for bullying. So firstly, you need to understand that there's no codified anti-bullying legislation in Ireland. There is a number of legal avenues, but there's no specific piece of legislation on the statute books that says bullying is an offence. You might find that hard to believe, you may be surprised to learn that, but that is the position. There's no codified anti-bullying legislation. So if you're bullied by an employer, or if you're bullied by a colleague, a work colleague, you do have fair degree of protection insofar as the employer can be held vicariously liable for the acts of the fellow employee, the colleague, in addition obviously to being liable for his own acts if the employer is the one who's bullying you. Before you do anything though, before you embark on any complaint or any cause of action or any claim or any legal proceedings, you should invoke the internal grievance procedures, the anti-bullying procedures in the workplace in the first instance. So you should exhaust whatever procedure may be in the workplace. It may be a grievance procedure you use, it may be an anti-bullying procedure you use, it may be a dignity at work policy or procedure that you use, but you do need to use internal procedures first, and you do need to exhaust those procedures. After that then, the legal remedies for bullying would include suing the employer for breach of contract. That is, you are entitled to enjoy a certain degree of protection in the workplace in order to carry out your duties and do your job. There's an implied term of trust and confidence that both the employer has in the employee and the employee is entitled to have in the employer. So a breach of contract would be one avenue for a bullying situation. The second would be a negligence claim. This essentially is a personal injuries action. So where you have suffered bullying and you've then suffered an injury, a psychological or psychiatric injury as a result of that bullying, then you're going to have a claim for negligence against the employer, and that will involve probably or almost certainly a claim to the Injuries Board in the first instance. And then the Injuries Board won't deal with it because it's a psychological or psychiatric injury that you're claiming. The Injuries Board will simply issue you with a letter of authorisation to bring a claim for a personal injury, and that will be essentially a claim for negligence. So you need to prove that the employer was negligent in the way that you were treated in the workplace. Essentially, you need to prove a number of things. The most important things you need to prove would be A, that you've suffered an actual psychological or psychiatric injury as a result of the carry-on in the workplace, as a result of the treatment that you've suffered in the workplace. Number two, you need to prove that that injury was suffered as a result of the negligence of the employer. So there's a number of things you need to prove, but they are the most important things. One, you suffered an injury, and two, it was the negligence of the employer that allowed that injury to occur, and therefore the employer is liable. You could also bring some sort of a claim under health and safety legislation to, for example, the Workplace Relations Commission, or indeed you could sue for breach of contract and include a breach of health and safety law. the common law obligation to provide a safe place of work, and a statutory breach of the Safety, Health and Welfare at Work Act of 2005, or whatever year it was. You could bring a claim also under equality legislation for harassment. Now, harassment is slightly different from bullying insofar as it's bullying that's kind of grounded in one of the discriminatory grounds, and there's 9 grounds of discrimination. So that's a harassment claim. You could also bring a claim for constructive dismissal. In other words, you could put up with the bullying for so long and then you simply have had enough. Remember, I have stated that you do need to use internal grievance procedures first. You do need to exhaust them. And after that, then you may be able to ground a successful claim for constructive dismissal if, after exhausting internal procedures, you leave the job and bring a claim against the employer for constructive dismissal on the basis that you cannot be expected to put up with it any longer, and that the conduct of the employer in failing to protect you essentially is completely unreasonable, and so unreasonable as to allow you to treat the contract of employment at an end. I would advise you to get legal advice. Choosing the best cause of action, the best cause of legal action in your case is critically important. The venues, as I say, that are open to you would include the civil courts, the Workplace Relations Commission, the Labour Court and the Personal Injuries Board. Choosing the wrong type of action or the wrong venue will cost you in the long run. I would caution you though about the Workplace Relations Commission and the Labour Court insofar as the referrals there, the claims there under bullying, under a bullying heading as it were, is limited enough insofar as you're essentially bringing a claim that the employer has failed to implement the dignity at work procedure or policy in the workplace, and the likelihood is that your claim there is going to be under the Industrial Relations Act 1969. You're going to be looking for a recommendation that the employer has failed to use the policies and procedures in the workplace to provide you with protection, but the award that you may end up with could be limited enough. Hope you find this video useful. If you do, you can give it the thumbs up down below. I would appreciate that. And my contact details are there on the screen. You may also be interested in subscribing to my YouTube channel. Forgot to say, on employmentrightsireland.com, that website that you see there on the screen, there's a huge amount of information about employment law in Ireland on that website. It's completely free. A lot of it has to do with bullying as well, and various cases involving bullying and people who were bullied and personal injury claims and so on and so forth. The other website that you see there, businessandlegal.ie, is my solicitor's website. That doesn't deal with just employment law. It deals with all aspects of Irish law, including personal injury claims, property and so forth.